Now, the Gauteng High Court is struggling with a massive backlog of civil cases. Now, in an attempt to deal with the backlog, the Gauteng Judge President Dunstan Mlambo has proposed mediation processes before civil cases proceed to trial. Mlambo has issued draft directives last week, and the Gauteng High Court has too few judges for the number of matters enrolled, with the earliest available court date in certain instances being 2031. Now, Gauteng is the largest and the busiest High Court division in the country, but for reaction and perhaps a little more engagement on this particular directive, we joined virtually by legal researcher at Judges Matter, Mbekezeli Benjamin. Mbekezeli, thanks so much for your time. Welcome to Morning Live.
Thank you very much, Sakina. It's a pleasure to be on.
So, given the dire state of the case backlogs in Gauteng, this mediation process that is proposed, would you say this is a move in the right direction?
Yes, it is a move in the right direction, Sakina. Currently, we are facing a very difficult situation in Gauteng, but it is a national problem where we just have too few judges for the population of South Africa. If we zoom in on Gauteng, for example, there haven't been any increase in the number of judges since 2008. And we know that in the last 17 years, the Gauteng population has gone from 10 million people to now 16 million people. So that's more than 50% increase in the population size. But the judges in that who have to serve that population hasn't increased. And so that's why we are seeing the delays that we see in the courts. And so this mediation process is trying to address some of those delays.
Perhaps just for context, the biggest problem is the lack of judges. Now, how dire is the situation in Gauteng, and how many judges would you say are needed, Mbekezeli?
So the situation is dire in Gauteng in particular because not only is Gauteng the population hub of South Africa, but it is also the economic hub. That's where most companies are headquarters. That is also where the government is headquarters. So most of the cases against the government, including national departments, have to go to the Gauteng division, which is in Pretoria and Johannesburg. And so that's why it receives more than half of all civil cases in South Africa. So what we expected to see is that the judge complement or the staff complement in those courts will align with those kinds of factors. But we unfortunately have not seen that it happen. So currently there are 82 judges in Johannesburg and Pretoria. And those judges have, like I said, have been in place since 2008. But what the Johannesburg Attorneys Association suggests is that we need a minimum of 20 more judges in Pretoria and 20 more judges in Johannesburg. And that is just a conservative estimate. We know that currently there is a committee that is chaired by the former Deputy Chief Justice Dikgang Moseneke that is actually looking at the exact number that should be allocated. But we do know that a minimum of 20 is required at each of the courts in Johannesburg and Pretoria.
So as far as I know, Mbekezeli, we don't have a lack of capacity in this instance. So is that correct? And if so, why then don't we have the requisite number of judges on the bench?
Yes, you are spot on, Sakina. We have tons of capacity. We have many skilled lawyers who would be judges by tomorrow if the posts were available. But the posts are just not available. And that's, unfortunately, is where the crisis is that government over the years has not been funding the judiciary adequately. Not only are there too few judges, but the other support systems to support the judiciary have also not been in place. In fact, over the last 5 years, we've seen successive cuts to the budget that is allocated to the judiciary. Like I said, Gauteng is one big problem, but the labor court is another problem that we know is a big crisis. There are 13 judges there who are supposed to serve the 62 million South Africans that are living in this country. And that is also not sustainable. Again, the labor court is essential because that's where workers' disputes go. And if people are dismissed, If they have to wait 5 years to get a trial date, then they're sitting unemployed for those 5 years.
Our apologies there to our viewers. Just a slight break there in the signal. So hopefully it will correct itself whilst I get to the next question, Mbekezeli. Getting back to Judge President Mlambo's proposal that cases be only set down for trial if they first undergo mediation. And speaking of civil cases, that is, let's just start off by explaining what civil cases are and then look at the proposal and its practicality.
Involve a crime. So usually there will be where, for example, you're owed a debt, or it has to do with a dispute between contracting parties. So we maybe go into business and we sign a contract and there's a dispute over the meaning of that contract, or I sold you goods and you haven't paid me back, then I can take you to court. Those are the nature of civil disputes. But for the purposes of the directive that the Judge President has put forward, he particularly targets the road accident cases, so cases against the Road Accident Fund, but also what are called medical legal claims, so cases where there's medical negligence and people are trying to get compensation for that medical negligence. Those are the main cases that are targeted by the directive.
And just how severe is the backlog in those caseloads at the moment?
So, in Gauteng, in Pretoria in particular, there are over 300 road accident fund cases a week. And the earliest trial date, if you have a road accident fund case, is 2031. That is 6 years from now. That is when you will get a trial date. And we know that in 6 years' time, a lot may happen. You may die because of your injury. Those injuries may get worse. Evidence might get lost, witnesses their memories may fail. And so there is a huge problem if people have to wait 6 years in order to address their medical legal claims or their road accident fund cases. So what the proposal that is put forward on the table is that those cases should be mediated. So they should be sent to a professional mediator who will sit and work with both the RAF or the state attorney and the private attorneys to try and come to some sort of settlement over that case.
But you spoke a short while ago about capacity constraints in the legal fraternity overall. So who are these mediators? Where are they going to come from?
So, unfortunately, we do have a big crop of skilled and trained mediators. In fact, there are accrediting bodies that run regularly courses on mediation. And in fact, it has been used quite a lot in the labor process. You know, the CCMA, the M in the CCMA means mediation. And so mediation has been part of the labor dispute resolution system. It also has been used in family law cases and in commercial cases. So what this proposal by the Judge President aims to do is to bring it in relation to these cases that are on the civil trial roll. So those cases that I mentioned involve the RAF and the state attorney. And those are mediators who will come from private practice, including advocates and attorneys who are skilled and who are senior. And they will play the role of, in football terms, a referee to try and resolve some of those questions.
Already some lawyers have raised skepticism about going through this mediation process in Mbekezeli, and they've argued in part that it would infringe on their client's right to access to courts as enshrined in the Constitution, and forcing them through this mediation process, which they say should be voluntary, would be infringing on those rights. What's your take on that?
Well, I completely understand their frustration. A lot of times we see, particularly in these kind of RAF cases, lawyers do have to go through a lot of hoops for them to get a trial date. And so I do understand their concerns about them being now forced to go through another process. But we must also remember that mediation has been in place since 2020 in the rule, in terms of Rule 41 capital A of the Uniform Rules of Court. So far, it has been voluntary, and so most people, even though the rule says they must seriously consider, what we see is that it's either not considered at all, or if it is considered, it's not considered seriously. So what this mediation process by the Judge President seeks to do is to make it more compulsory. So when you want to get a trial date in Gauteng, you first have to undergo a mediation. And so you have to seriously engage in that process. You have to narrow down the issues that are in dispute, because often you'll find that a trial will be set down for 3 weeks because there are 10 issues that need to be resolved. But when in actual fact, the issues that are in dispute probably are 2 or 3. And so a mediator will help to narrow down those kinds of issues. And so yes, it is an extra step. It will require extra money, unfortunately. But in the end, if you're able to get a trial date sooner than 2031, that will save you a bit of money. And in fact, it will promote access to the courts in terms of Section 34 of the Constitution.
Mbekezeli, thanks so much for your time this morning. Mbekezeli Benjamin is a legal researcher at Judges Matter, and speaking about the proposed mandatory mediation for civil cases, which is, of course, out for public comment at the moment.